punishable as a felony.
Mr. Smithy.
Thank you, Mr. Speaker. This is the final piece in the package that has been put together. It addresses a special category of criminal defendants, and these are people who are in this country illegally, either by virtue of having entered the country illegally or else staying after their authorization had expired. We took this resolution as it came from the Senate. We were a little bit concerned with the definition of what an illegal alien, what constitutes an illegal alien. And we didn't want to capture any of the people that we shouldn't be capturing here. And so we refined that definition as it is written in the most recent version of the SR. We also dealt with the problem or the situation where the Senate had basically applied this to any felony. Well, we looked through the felonies, and Legislative Council had inventoried all the felonies that we have in Texas, and here's the list. It's about 30 some odd pages with probably 30 felonies on each page. It goes from everything from operating a grain elevator without a license to slandering a savings and loan. Those are all felonies that are on our books. They go all the way from the Agriculture Code through the Business and Commerce Code, Health and Safety Code, Penal Code. They're all over. They're in all Natural Resources Code. They're all over. So these aren't people that we necessarily need to lock up and throw away the key. Somebody that slanders a savings and loan. Okay, we agree. So we went through carefully and tried to pick out the offenses that pose either a real threat to the safety of society or a threat basically to our system of government. And after we had done that, it may not be a perfect list. We tried to match that with the impact that this would have on the justice system. And so we limited those felonies down to the ones that we considered essential. Now, let me just say this about the resolution, which I think needs to be said. This deals only with people who are here illegally. They are covered under federal law. Virtually, really, as far as I know, everyone who is covered by this act is covered by federal law, and particularly with the Lake and Riley Act that passed earlier this year. And Sheriff Louderback can explain it better than I can, but because he's dealt with this for years, but what happens is when the federal statute defines alien basically as anyone who's not a citizen. So, or maybe a lawful permanent resident, but I think it's just a citizen. There's a very broad class of alien. Now, if you're an alien and you are arrested for any of these crimes, these serious crimes, and Lake and Riley Act expanded that list of crimes, you automatically are subject to a detention hold by ICE. ICE will place a hold on that individual. They can't be released for any reason. And you can post a bond, but you can't get out of jail if you're in that category. And so almost everyone that this resolution would apply for is already covered under the Immigration Naturalization Act, and they're not going to get out of jail. They're ultimately going to end up in the detention or custody of ICE.
Mr. Romero, for what purpose?
Does the gentleman yield for questions?
Let me finish, then I will.
Yes. Not at this time.
Thanks. So the purpose of this is to capture that very small group that may slip between the cracks. And these are going to be people who are in the country illegally and who have committed some very, very serious crimes, or at least are accused of committing those crimes. And there has to be a finding of probable cause by a court, not just a grand jury, but by a court, that there's probable cause that the acts alleged have been committed. This resolution in the Senate was entitled the Jocelyn Nungery Act. We're all aware of the tragic case of Jocelyn that occurred last year, brutally assaulted, murdered, and her body just just left for dead. And such a tragic occurrence. We've had the opportunity to visit with members of her family who are really involved now in trying to make a positive change as a result of what happened to Jocelyn. We're not trying to be unfair here or difficult, but we do want to protect our little girls and our little boys and our mothers and everybody that is vulnerable in this society from these things that can happen. And so I will yield for questions.
Romero, for what purpose?
Does the gentleman yield for questions?
Gentleman yield for questions.
Yes, sir.
He yields for questions.
Just a couple of questions, Chairman Smithy, and thank you for the, I think that everybody agrees that we should all protect young people regardless of who that perpetrator is. So in the United States versus Salerno, the Supreme Court Chief Justice William Rehnquist wrote, "In our society, liberty is the norm, and detention prior to trial or without trial is the carefully limited exception. Can you talk to us about SJR1 with respect to the principle of liberty being the norm for the people that are affected by it? And are you aware that the U.S. Constitution requires the judges to make individualized determinations about whether a person poses a flight risk or danger to society before denying bail? And do you believe that this complies with that requirement?"
I think it does. For example, I mean, like we're essentially doing this now, Mr. Mayor. The federal government is doing this. Once they put a detainer, there's no release until ICE determines that the individual can be released. And so,
So then what's the purpose of the bill if it's already being done now? Why would you take an additional step if you've just stated it's already current law?
Well, it's already current law, but we still have very real cases of people, for lack of a better term, slipping between the cracks. And those are typically the people that are causing the major problem and posing the biggest risk to the security and safety of our citizens.
Can you tell me where those cracks occurred, Chairman Smithy?
They can occur if ICE misses a detainer. Sometimes in your sanctuary cities where you don't have someone reported, there are a number of ways that the system can fail to detect those individuals.
But we're talking about folks that are already incarcerated at this time, correct? So they would have already been in our county jails, not a city. So it wouldn't be a sanctuary city because it's not cities that jail.
Well, if they're sanctuary cities, some sanctuary cities don't notify ICE in the event of a detention, or they don't even make an effort to determine if the person's illegal or not. That has happened in the past.
But if it's of these particular crimes that this bill entails, as you laid out, these persons would not be in a city jail. They would be in a county jail at that point. Is that not correct?
This level of offense would be in county jail.
So this doesn't have anything to do with sanctuary cities per se?
No.
Okay. So can you point to specific offenses for which denial of bail would be required under SJR1? And when you were working on this bill, did you consult any findings or expert testimony showing a link between immigration status and actual pretrial behavior?
Well, I do know that that it's hard to have any real statistical study because of the ICE detainers, because you don't have. It's hard. It would be hard to go out and do a study of whether people who are in the country illegally are more of a serious flight risk than those who aren't.
I mean, wouldn't you have the data to show you who those persons are?
Well, the data is going to be misleading because most of these people, are, as I mentioned, are already subject to an ICE detainer. But common sense says, and generally one of the factors that is considered in determining whether someone is a flight risk would be their roots in the community, whether they have family in the community, a home in the community, a job in the community. In most cases, a person, not every case certainly, but in many cases, a person who is in the country illegally doesn't have those roots. It's not case, as I say, in all cases, but it's the case in many.
So without the study showing those that have been, that have received the ICE hold, are you aware of any other data that shows that or a pattern that shows that these people maybe fail to appear in court in larger numbers, or that those persons are more dangerous to public safety as compared to other folks that are not of this immigration status?
Yeah, I would just give you this, that during the Biden administration, there was a policy when an illegal alien was apprehended, many of them had been instructed to simply claim asylee or refugee status when they were apprehended. And so the practice was to write a citation, basically requiring them to appear in court sometimes as far as 5 to 7 years later. And I know the appearance rate for those who were cited was not good at all. It depends on what time period you're looking at, but in most time periods, it's around 10 to 15% of the persons who receive a citation that actually show up for their hearing. And so
Understood. And those persons would have a hold of some sort if they didn't go to trial. But my question was, if you believe that these persons present a higher risk to public safety as compared to others, just because they didn't show up to their court date wouldn't seem to me, other than just not going through that civil procedure, they didn't necessarily do that. I'm going to move on to a different question, Chairman, if you don't mind. Why did your bill categorically forbid granting bail or pretrial release? In expanding the ability of judges to deny bail through an individualized assessment of flight risk or dangerousness, inadequate to achieve the state's objective in these cases. So what alternatives to categorical pretrial detention were considered for the people described in your bill, such as supervised release with GPS monitoring as an example?
Well, I would say this, that the federal government doesn't do any GPS monitoring. And if we bond someone out who is here illegally and who is accused of committing a crime, basically what we're doing, Mr. Romero, is we're giving them a head start on the federal authorities. That's all we're doing. We're saying, okay, you're out of jail. You probably have 24 to 48 hours to escape and get away. And they may very well do it. We may not. I'll give you an example. I mentioned in my opening remarks a moment ago on another bill of a young lady who was raped in Williamson County. The rapist, after conviction, he was an illegal alien. He was allowed out on bond, and he hasn't been seen since. We don't know where he is. He may be causing havoc in another part of the state or another part of the country, or he may be back in another country. We don't know.
Chairman, I have other concerns, and some of those want to ask some more questions. I do have deep concerns about defining illegal alien and some of the folks that you've left out, which I want to come up and discuss with you while others ask, and maybe potentially through some amendments. I think that you have folks that are DACA recipients that are not in the definition as those people that have status. I think that those of us that know these kids, or maybe our own children have gone to school with them, know these are some of the best and brightest people that we have in our state. And I think that your bill in defining illegal alien left those folks out and left them in a position where they feel that they're at more risk than anyone else. And in effect, these people see themselves as U.S. citizens. So I'll talk to you about that, but I want to do that through the amendment process.
Okay.
Thank you, Chairman.
Mr. Speaker,
Ms. Gomez, for what purpose?
would the gentleman yield for some
Mr.
questions?
Smithy, would you yield?
Yield.
Thank you.
Thank you, Chairman Smithy. I appreciate the discussion we're having today because we're about to presumably ask the body to do something of great constitutional magnitude that affects not only the Texas Constitution, but has implications on the United States Constitution as well. And so I think what you were discussing a minute ago with Chairman Romero was the individualization, the individual process, that the detail that each defendant who's brought forward, each accused is brought forward, is entitled to when undergoing a bail hearing. You'd agree with me that categorically under the United States Constitution, each individual is entitled to, for a magistrate or a court, to individually determine their circumstance on a case-by-case basis, correct?
Not necessarily. I think someone who's here illegally is entitled to.
So prior to what you're trying to do here today, you'd agree with me that under the United States Constitution, each individual is entitled to an individualized case-by-case analysis of their accusation in regards to bail, prior to what you're trying to do here today.
No, I don't.
In which instance is someone not entitled to an individualized analysis of their case?
Well, you asked me about constitutionally. I think even
Is
someone.
each person
Okay, let me answer.
constitutionally not entitled to an analysis of whether or not they're a flight risk, the nature and circumstance of their crime, whether or not they're a danger to society? Are those not the enumerated factors that each individual is entitled to under a bail analysis?
Well, you're asking me two different questions. One, you're talking about bail analysis, and you're talking about due process under the Fifth Amendment.
Okay, let's
If-
talk
if-
about bail.
Well,
Right now, as we stand here, cloaked under the United States Constitution, is each individual not entitled to a case-specific analysis of their circumstances?
that is not in the Constitution.
So right now, would you please give me an example, absent this legislation, where an individual is not entitled to a case-by-case analysis of their specific circumstances regarding bail?
Well, let me just say this, that if you've got an ICE detainer on you, you're not getting
Chairman,
bail.
I'm just asking you to answer the question.
No,
Would you
well-
please explain to me, aside from the legislation that you're trying to pass here today, wherein under the United States Constitution, an individual is not entitled to a case-specific analysis of whether or not they're a flight risk, the nature and severity of their crime, whether or not they're a danger to society? Isn't it true that each person is entitled to that analysis, as we stand here today?
Well, let me finish answering your question, okay? That's only fair. And so what I would tell you is, to my knowledge, there is nothing in the United States Constitution that says what you've just said or deals with what you've just said.
It's your
I will
opinion
tell
that
you.
there's no
Well, let me finish.
constitutional
Let me
right to
finish.
bail?
Hold on. Let's don't talk over each other. Let me finish.
I know, I'm getting
No.
just as frustrated. I agree.
Okay, so you have the Fifth Amendment. Courts have, the Fifth Amendment basically guarantees certain rights, a number of rights, multiple rights to persons. Courts have determined the use of persons to indicate that it would apply to all persons, not just citizens. Other
Right.
provisions apply to citizens. What is due process and what constitutes due process under the Fifth Amendment is generally left to the courts, both federal courts and state courts. And to answer your question, we've had people that have briefed on the United States Supreme Court, been briefing attorneys there, review this. And we specifically reviewed it by constitutional lawyers and people who have actually been in the Supreme Court, working in the Supreme Court, who have told us that what we're doing here is constitutional.
Respectfully, can you please articulate a situation outside of this bill wherein individuals are not entitled to a case-by-case analysis of the factors surrounding their accusation for bail?
Well,
There is
I
none.
gave you one. An ICE detention. I mean, you're in custody.
Right, which
You're
would
in
absolutely
detention.
make what you're trying to do here moot, obsolete, repetitious, redundant, excessive, unnecessary, because you've already articulated on a multitude of occasions that the federal government is already doing that, correct?
Well, if they do, it doesn't affect it. But as I told you, there are some that get through the system anyway, and they're released out into the public, and those end up being the most dangerous people that we have out there, and they have caused and they will cause real harm. And all I'm trying to do is protect these citizens. I mean, this is not a first-year law school discussion. We're talking about the real world here. We're talking about little boys and little girls who have been brutally savaged and raped and murdered. And we can't keep doing that. We know that what we're doing now is not working. The human tragedy that has occurred because we've had this law school debate about rights. What about the rights of these victims? What about Jocelyn Nungery?
Respectfully,
What
Chairman,
were her
staying
rights?
on the bill, staying on the bill.
I'm on the
Thank
bill.
you.
That's
Let's stick the conversation to the bill and do not talk over each other, please, so the members can hear the debate.
Thank you, Mr. Speaker. Chairman Smithy, I believe earlier what you were articulating in regards to the Supreme Court has analyzed that all persons are entitled to constitutional benefits. Is that correct? You were referring to equal protection, not exactly due process. You're not,
No, the gentleman's time has expired.
Mr. Speaker?
Yes, Ms. Gomez?
I'd move for an extension.
There is objection. This is a majority vote. Vote aye, vote no, members. Aye for the extension, no against the extension. Record vote has been requested. A record vote is granted. The clerk will ring the bell. Show Ms. Gomez voting aye. Mr. Smithy voting aye.
Again.
Show Mr. Tenderholt voting aye. Have all members voted? Being 118 ayes, 21 nays, the time is extended.
Thank you, Mr.
Go ahead,
Speaker.
Ms. Gomez.
Chairman Smithy, who, in crafting your definition of illegal aliens in the bill, what experts or agencies did you consult in crafting said definition?
Well, I know we, and through the Speaker's office, we went through, we talked to some immigration lawyers who are involved in this, and we weren't really happy with the Senate definition, so I think we refined that some. And you know, this is where we landed to try to land this population or this class of people here who are here in this country illegally. And honestly, when you talk about visas, both permanent residency and temporary residency, you're talking about literally hundreds of status classes that you're dealing with. And so it's a very complex issue, and we tried to capture. First of all, our definition is narrower than what you have in federal law. Federal law doesn't really define illegal aliens. It defines alien, and the definition of alien is much broader than what we have here. That's why we use the term illegal alien, because we wanted to narrow it from the federal statute, which requires a detention in even more cases than what we're applying this to.
So in this case, in this instance, let's assume that there's not an ICE detainer on an individual who's brought forward, meaning in this case, for whatever reason, ICE hasn't pegged them in the system quite yet. They're brought forward, they're about to be magistrated. Whose burden is it at this point to prove that an accused meets your definition of quote-unquote illegal alien?
It's the prosecution's burden.
By what standard of proof?
By, I think, by probably preponderance, more likely than not. Although, if you can prove,
But you'd agree with me that your bill does not articulate that. What standard of proof?
we do not articulate a standard, but let me just say, this really isn't rocket science. What they're going to have to do, they have the burden to prove it, and they're going to have to put on evidence.
What type of evidence would they put on?
Well, it's primarily going to be records that come from the federal government, from INS and ICE and Customs and Border Patrol.
At this point, you'd agree with me the accused has absolutely no legal obligation to comply or to violate their right to remain silent in this process, to participate in any inquisition in regards to their immigration status.
I think they have that right, certainly. And because what you're going to have to do, if you're the prosecution, you're going to have some, as a practical matter, you're going to have documentary evidence showing the immigration or non-immigration status of this individual. And I will say, if in those rare cases, if the documentation turns out to be wrong or outdated, the defendant can always come back in and show that at the time.
Through what process of appeal or what mechanism, what right do the defendant have to contest that finding?
It's not really an appeal, but the bond status, or the bail status for this individual, if it's determined later, I mean, if nothing else, a habeas corpus, there are several ways that you can bring this to the court's attention. It's not a permanent decision if it's not correct. We want it to be corrected.
So what?
But we don't want to put that in the Constitution.
Right. What mechanisms do you intend for the magistrate or the district court to utilize to make this determination, this assessment of immigration status?
Well, you're going to have the assessment with the federal documentation, From the ICE, generally it's an ICE document. The ICE document will tell you their status, immigration status or citizenship status. And once that status is determined, and it will be documentary evidence, it's really a very easy call on the part of the magistrate to see whether they fit in the terms. And we try to make it as simple as possible to see if they fall within the category of a definition of an illegal alien that's defined in the JR.
So you'd agree, I guess we keep referring to these documents. I mean, ordinarily, I can't just go to court and introduce a document. For example, there are evidentiary rules and procedures that prohibit this specific type of hearsay. Again, what are we asking of our state agencies to do in compliance with federal agencies to come prove up these documents? I don't just go and say, here's someone's visa that's expired, right? That's completely a hearsay document. How do we intend for them to prove this up now?
Well, this is at the magistration level. And so, you know, you're...
Wherein the rules of evidence still apply.
Well, at the magistration level, the magistrate has access to the criminal history and to the public safety report and a lot of other documents that aren't necessarily verified as evidence in the case, but has access to that information. And this is just information that allows the magistrate to make a decision in accordance with the law.
Without reviewing verified documentation?
Well, it's official government records that have come in from probably ICE, or it could be...
Again, under the rules of evidence and procedure, these documents had to be proven up. I mean, that's the
But
first
I don't
thing.
think that applies to the magistration hearing.
You don't believe the rules of evidence apply to a magistration hearing?
Well, not necessarily, no. I mean, because a lot of rules don't apply. The magistrate's just setting bail in that situation.
So it's your understanding now that a magistrate can use unverified documents to make a federal determination about immigration status so as to restrict their right to bail?
If it's a problem, the records can be verified with an affidavit very easily. So I don't see that being an obstacle at all.
Again, documents with affidavits are not substantive evidence to prove up in court, with all due respect.
They come in under official government record exception to hearsay or the business records exception to hearsay. So yes, they are admissible in a court, and they would be admissible in a magistrate's hearing.
It's your contention now that they should utilize business records affidavit to prove up these federal documents?
There are several hearsay exceptions that would apply if we assume that the rules of evidence apply, which I don't believe they do.
Now that they're going to be making these determinations in regards to immigration status, what training do you anticipate that our Texas magistrates or judges should have over determining immigration status?
I don't think they need any training to do this. I mean, all they have to do is look at the status that's revealed on their documentation and look at the constitutional requirement, and it will be self-evident whether the person falls under this category or not.
Respectfully, Chairman Smithy, I would argue there are immigration judges who spend hours making this careful determination, entire courts that have been carved out alone to make these very carefully planned out judicious determinations, and it's your opinion that a magistrate can simply do it. I believe you said it's obvious. It feels quite demeaning and insulting to the process that we give at this point at the federal level to these individuals.
Well, let me just say this. Immigration can be a very complex matter, but we try to make this categorization as simple as possible. And I believe it is simple enough that once the documentation is obtained, it will be obvious, it will be evident as to whether a person falls into any of these categories or not.
Respectfully, Chairman Smithy, I agree with you. Immigration determinations are an extremely complex matter, which is why I don't believe this HJR satisfies that with the way this is construed, and placing this burden on our magistrates who are already overworked and underfunded, and our district court judges who at this point do not have the resources available to them to make that determination. Thank you.
Okay, thank you.
Aaron. Mr. Speaker,
Mr. Romero, for what purpose?
I respectfully raise a point of order against further consideration against SJR1 on the grounds that the caption fails to give the legislature and the public reasonable notice of the subject of the proposed measure as required by House Rule 8, Section 1A1.
Bring your point of order on it down front.